Hello and welcome to Another Day, Another Evil. I'm your host Melissa.
And I'm Georgina, and this week it's my turn to bring you something a little bit different. So, R.V. Brown 1994 was a landmark case in UK law. It was one of the most controversial criminal law decisions in modern British legal history. And throughout the episode, I've tried to keep the legal jargon to a minimum, but some of it is necessary. The case raised a deceptively simple question. Can an adult legally consent to being harmed? And the answer from the courts would spark decades of debate about personal autonomy, morality, privacy, and the proper limits of criminal law. But to understand why it was such a landmark case, we need to look at the law which existed before it. So the law regarding consent in assault cases was governed primarily by the Offences Against the Persons Act 1861. And historically, courts allowed consent for minor scuffles, but still tended to criminalise intentionally inflicted serious injuries. English common law recognised specific exceptions where individuals could legally consent to harm. These accepted exceptions included medical procedures, properly conducted sports such as boxing and rugby, manly horseplay, and tattoos and piercings. And in these situations, the law recognised that people voluntarily accepted a risk of injury. However, there was uncertainty about injuries deliberately inflicted outside these recognised activities. The key pre-Brown authority was R.V. Donovan in 1934, where a man beat a woman with a cane for sexual gratification. And although she had apparently consented, the court held that consent could not excuse bodily harm that went beyond what was described as a transient and trifling injury. This suggested that consent might not be valid where actual bodily harm was intentionally inflicted.
That's interesting, given the time period and then, of course, kind of women's rights and... Yeah, I think that's just interesting because domestic violence hasn't been recognised until much recently, has it? So
No.
Interesting that in 1934 you couldn't.
Yeah, it was brought forward not as a violence thing. It was brought forward as an assault.
Okay.
So it wasn't being brought forward as domestic violence. I think if it had have been, the decision would have been different. Whereas it was brought forward as, can you they're saying that she consented to being hit, but the outcome of the harm was what they were debating.
Yeah, I still think it's interesting though, because obviously
So
people, even if you in a domestic violence context, people are in a lot of beating cases, if you like, they do sustain injury.
Yeah.
So yeah, it's interesting that this is kind of different.
Yeah. And another significant pre-Brown influence was the Attorney General's reference number 6 of 1980, which involved a street fight between two young men who willingly agreed to fight each other. The court ruled that consent was not a defence to injury causing actual bodily harm unless it fell within the recognised exceptions, which I said earlier.
Makes sense.
So it created an important principle. So the law was basically willing to tolerate some injuries, but only in a socially accepted context. So by the early 1990s, the law remained uncertain and fragmented, and no case had directly confronted the issue that R.V. Brown would raise. So the facts of R.V. Brown were unusual and highly controversial. A group of adult men engaged in consensual sadomasochistic sexual activities since 1978. The participants were all adults. The activities always took place in private. There was no complaint from any of the participants. No one required serious medical treatment, which I think it's important to note here, because there were no major costs to the NHS system, which is a big debate within this sphere, is that if you're consenting to harm, it is a cost to
The public,
everybody.
the taxpayers,
yeah. And no participant withdrew consent.
Okay, first thought, the reason that this was controversial is because it was a group of men
Yes.
engaged in
100%.
sex.
Yeah.
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 That's, yeah. That's the bottom line.
Yeah. I think if it had been a group of men and women,
in specifically the heterosexual,
yeah,
the man beating the woman, like, yeah, in that dynamic, yeah.
But obviously, you can then look at Harvey Donovan, where it actually was decided that it wasn't okay.
Yeah.
But I think that is, like I say, highly controversial because it was a homosexual domain.
Yeah.
So the activities included acts such as beating, branding, genital torture, the infliction of injuries amounted in law to actual bodily harm, and in some instances wounding. And I think it's important to say that the evidence came to the police's attention not because anybody reported the crime, like I said, but because investigators discovered the videotapes that they made during an unrelated investigation.
Yeah, very against the homosexual, yeah.
So the defendants were charged with offences under Offences Against the Persons Act 1861. Their defence was straightforward. Every participant had consented, and therefore they argued that no crime had actually been committed. The case reached the House of Lords in a narrow 3-2 majority verdict. The House of Lords rejected the defendants' argument of consent, and therefore the appellants pled guilty and were sentenced to terms of imprisonment. So the appellants appealed against their convictions, stating that a person could not be guilty of assault occasioning actually bodily harm or unlawful wounding in respect of acts carried out in private with the consent of the victim. The Court of Appeal dismissed their appeals, and the appellants then appealed to the House of Lords. The majority reasoned that society had an interest in preventing violence and protecting public health. They feared that allowing consent in such circumstances could undermine those interests. And one of the leading judgments came from Lord Templeman, who characterised the activities as harmful and contrary to public policy, and as a result, the convictions were upheld. So what makes R.V. Brown so interesting is that two of the 5 of the judges strongly disagreed. Lord Mustall argued that criminal law should not interfere in the private sexual conduct of consenting adults, and warned that criminal law should not become a vehicle for enforcing moral disapproval, which obviously is massively what this did.
Yeah.
If you ask me.
Yeah. And can I just point out that the fact that this didn't happen until 1994, but like the whole rape in marriage thing was only a few years before.
Yeah.
It's bonkers.
Yeah.
Sorry, just like completely unrelated, but like the kind of, yeah.
It has its place though, doesn't it? Because it's still the same. It's within the same sphere of discussion. I guess.
Sorry, I've maybe worded my point wrong. I'm thinking it's weirder that it took this long for rape in marriage to be fully criminalised, only 3 years before this, and then they decided that this was also not okay. Just, like a weird timeline of decisions.
Yeah. So, why is R.V. Brown still studied and hugely debated in law schools more than 30 years later? Well, there are several reasons. Firstly, it defined the limits of consent. Brown established that the modern rule that consent is generally not a defence to the intentional infliction of actual bodily harm, unless it's an activity that falls within the recognised exceptions, which remains one of the foundational principles of offences against the person. Secondly, it also raises questions about autonomy. The case created a direct conflict between two competing values. On one side was individual freedom. Adults should arguably be free to make the choices about their own bodies, which is something that arguably is being fought still today.
Yeah.
And on the other side was the state's interest in preventing violence and protecting society. Brown forced the courts and academics to confront the question, who owns your body, the individual or the state? And I think that that's one of the biggest reasons why it is debated today.
Yeah.
Is the fact that if you consent, then it's consent.
Yeah.
And consent is such a big one in other crimes, such as rape. Like, that is the biggest that is the arguable point.
Yeah. I think as well, the massive difference is if you're a consenting adult and have consented in the proper sense of like it's freely given, etc., etc.
Yeah.
And then you get a criminal record, and serve prison time, and you are in there with people who have committed the same offence but with no consent. Like, that is a massive difference.
It's huge.
Your life's ruined.
Yeah. Because they didn't think that they were committing a crime.
Yeah.
Like, they were like, what we're doing is completely fine because we're not committing a crime.
Yeah. And yeah, it's not that one of them has decided to go to the police and be like, I'm actually not happy anymore.
Yeah.
I mean, even if you take out the consent part, it's not that they've turned around and just kind of like spitefully gone, I'm not, like, I've had a bad breakup, I'm gonna use it to spite them, like, whatever. Like, yeah, like, it came about in a completely different context as well.
Which is one of the other things as well, is that in the actual R.V. Brown, if you look at that case just plain on facts, it hadn't, like, it didn't make any difference to society.
Yeah.
Like, it didn't cost anybody anything.
Yeah.
It's not like they were in and out of hospital and that's why it came about.
Yeah.
Like, there was no issues.
Yeah.
They all consented.
Yeah.
No one got hurt where they had to then use taxpayers' money.
Yeah.
They dealt with it in their own kind of home and whatever. So,
yeah. Do you know how much prison time they got?
No.
Because that'd be interesting, because I'd probably be really pissed off at the fact that there'll be actual rapists out there and actual people committing violent acts who probably got less prison time.
They received prison sentences ranging from 12 months to 4 years and 9 months.
Yeah, see, that seems really harsh.
Yeah.
For something that is not a violent act because you are a violent person.
Yeah, people who kill people get less.
Yeah. And rape people, they get a slap on the wrist. Like, why were they not just given, like, a slap on the wrist and a warning that actually we've decided it's against the law for you to do this?
Yeah.
Okay, fine.
I think it's such a big debate still.
Yeah.
And as well, I'm going to come on to this, but the courts can't even keep to this decision.
Okay.
So there's obviously an issue with it.
Yeah.
Which I think definitely needs to be looked into.
Yeah.
So it also highlighted the role of morality in criminal law. Many critics argued that the majority's reasoning reflected moral disapproval of the homosexual sadomasochistic practices rather than genuine concerns about harm.
Definitely feels that way, doesn't it?
Yeah. Because I think as well, like, for it to have come about because the police randomly happened to see these videos.
Yeah.
If that had have been a man and a woman behind closed doors, they'd have probably had a laugh and a joke about it and gone, oh yeah, fine. Because it was a group of men doing it to each other.
I think even if you'd have investigated that to the point of questioning them to ask whether
it was consensual.
Whether everybody agreed to participate in that, fine. Yeah. But then when they were all like, oh yeah, and we knew we were being recorded, because that's another thing, like you can consent to the act but not the recording of it. Yeah, fine, but then that's where your investigation stops.
Yeah.
In my opinion.
I agree. So the criticism became even stronger because the activities were private and fully consensual, like we said, and then the case therefore became central to debates about whether criminal law should enforce moral standards. And lastly, it influenced human rights litigation. The defendants later challenged their convictions before the European Court of Human Rights in Lasky, Jagard and Brown versus United Kingdom. The court accepted that private sexual activity fell within the right to private life, but held that the interference was justified in the interests of protecting health. So the convictions therefore remained valid.
Seems odd. I'm pretty sure we've seen people challenge stuff to the EU and they've gone, oh yeah, no, that's not okay. And you're like, what? I mean, look at the James Folger case, the two 10-year-olds that got fuck all time for torturing a toddler.
Yeah. And I think, again, it would be fine if, or it would be less of a debate if like the case in general came up because they were using the NHS every other week for I don't know, infections from the branding or whatever.
Yeah.
But I find it really difficult when they say it's in the interests of protecting health when that wasn't even part of it in the first place. I find that really difficult when they're saying, like, yes, the sexual activity should have stayed within the private life and then shouldn't have come any further, but it protects health.
Yeah.
But again, like, it then it like opens the floodgates, doesn't it, to if the ruling had have been, no, it's private life, and then a case came about where they were going to the NHS all the time, then it would have.
And I think the health one only, in my opinion, only comes into that you can only use that argument because we have
the
funded NHS. If you were going to private healthcare, if you're fucking paying for this, then which, I mean, a lot of the European countries have kind of like a dual system, don't they?
Yeah.
If you're paying for it, then it's your decision to do.
And I think that there's so many other things that harm people that they do.
Well, I was just going to say drugs.
Drugs.
Why are we not... By that logic, everybody who takes drugs should be in prison.
Not even if we talk about drugs in the sense of illegal drugs. Even if we talk about, like, cigarettes that are taxed.
Yeah.
Alcohol, which is taxed.
Yeah.
They kill people. They probably kill several people every hour.
Yeah.
If you look at actual statistics.
Yeah, and that's a strain on the NHS. Look at, like, A&E on a Friday night, for example. That's mostly alcohol related.
Yeah.
Yeah. So everybody doing that should be criminalised. Everybody who takes drugs, because that's definitely a health risk.
Yeah.
And you, as a drug user, I'm not saying, by the way, just to clarify, I'm not saying we should be criminalising drug addicts. I'm saying the logic would also, therefore, should apply to drug addicts. And obviously that is not what should happen. I'm not saying that, I'm saying this logic should. Yeah, just to clarify.
Also should then apply to all of these other things.
Yeah. If the argument is it's about health.
Yeah.
But to me, the argument's about consent.
Yeah.
If you've consented to it,
then you've consented to it.
Yeah.
Yeah. They are then just pulling in this whole health thing.
Yeah. And then at what point as well does it become like an offence? Because if you're into kind of that and you just get a bruise.
Yeah.
Compared to a gash. I don't
like actual branding.
Yeah, like.
But then it's like actual. If you look at it, if someone's been branded, surely that's exactly the same as tattooing and then removal of the tattoos as well. Because it's
also,
like
just thinking there's that new thing where people are branding each other with the dry ice type thing. It's like a freezing brand.
Oh, right, okay. Yeah, so like
that seems to be a trend at the minute.
Yeah, so at what point then are they gonna start arresting everybody because of that?
Yeah.
Because people will be putting that everywhere.
Yeah.
Why is
and it's
tattooing and piercing okay?
Yeah.
When them branding their initials on someone's bum not okay?
Yeah.
If you've consented, they're both consensual.
Yeah. And it's not like they were doing it not in private, which I can understand. I mean, that would be a different offence because it would be like indecent exposure or whatever. But like, to me, the issue there is consent, not public health, not injury. Because otherwise, if that's the argument, then there's all these other hundreds and thousands of things that people do every single day who would also that should fall under that and should. Everyone should be I think everyone I know under that logic should be a criminal.
Yeah.
Because they've drank too much.
Yeah.
One day.
Yeah. Or drank too much every day of their life. Like, there's alcoholics out there who need help. Obviously, I'm not saying that they, like you say, we're saying under this argument, it should then apply to everybody else. But the alcohol industry is massive, and that is something that is taxed, but there are people who are genuinely being hurt by it every single day going to the NHS because they need their liver, their stomach's pumping, they've fallen and broken things.
Yeah.
There's countless of things that people go to the NHS for just because of alcohol.
Yeah.
So surely, in the interests of protecting public health,
that should
every person that drinks alcohol to excess and hasn't used the NHS should be criminally responsible.
Yeah.
And go to prison.
Yeah.
It's so frustrating. Like, we both fall on the same side of the coin and the same argument. It would be interesting to have this conversation with somebody who didn't fall in this, on this side and did fall on the other side.
Yeah. If you are one of those people, please
reach out and tell us. Tell us what your thoughts
Email
are.
us politely.
Yeah, please don't hate mail us.
Yeah, just email us politely and tell us your arguments, because from my point of view, this is an issue about consent, and if you have given consent freely, that's it. That's the end of discussion.
Yeah.
You might come onto this. They've not caused a death, which I think is different.
Yeah.
Because, I think if you then cause death, that's very different.
Yeah, no.
And I know there are lots of debates around that kind of that aspect of sadomasochistic
and there was the whole thing a few years ago with drugs on that one, wasn't it? And whether, as a drug dealer, you were criminally responsible for people who overdosed and bought from you.
I'm
not actually sure where that ended up, but I know that there was something, I think during university it came about for us, so like we talked about it in that sense. But
we don't have assisted suicide here, in this country, so to me, if your sadomasochistic acts result in death, then yes, criminally responsible. But if you're consenting to some kind of harm and you're okay with that, then that's it.
Yeah.
Because how many
end of the story.
Yeah. Because as well, how many people end up in fights, end up in this, that and the other, and nothing happens because either somebody doesn't press charges, or like the CPS decide that like there's not enough evidence. Like, there's plenty of people who are willfully committing acts against people who are not consenting to it, which result in injury and serious injury, but there's no criminalisation for them. Yeah. Very strange.
Hence why it's debated.
Yeah.
So, like I said earlier, subsequent decisions have struggled with Brown's legacy. R.V. Wilson in 1997, so only a few years after Brown, in a branding case involving a husband and wife. So the Court of Appeal overturned the conviction as it questioned the public interest in interfering in the private acts of consenting adults.
Heterosexual relationship then.
Yeah. The court held, quote, consensual activity between husband and wife in the privacy of the matrimonial home is not, in our judgment, normally a proper matter for criminal investigation, let alone criminal prosecution. Accordingly, we take the view that the judge failed to have full regard to the facts of the case and misdirected himself in saying that R.V. Donovan and R.V. Brown constrained him to rule that consent was no defence.
I mean, the original judge wasn't wrong.
No.
Under those rulings, then consent isn't a defence, but basically they've decided that because it's, without saying because it's husband and wife. Yeah. I mean, they have said because it's husband and wife in at home.
Activity between a husband and wife in the privacy of their home.
Yeah, so.
But R.V. Emmett in 1999 followed Brown and rejected consent where more serious injuries occurred during sexual activity. So Mr. Emmett caused ABH to his fiancée in 2 incidents where he placed a plastic bag over her head, causing loss of consciousness, and ignited lighter fluid on her breasts, causing burns.
And she consented to that.
Apparently so. So there's been major academic debate around the ruling in Brown. Critics argue that the recognised exceptions are inconsistent and the decision places too much emphasis on public morality and it gives sufficient weight to personal autonomy. Supporters of Brown responded that the state has a legitimate interest in preventing serious violence, and the criminal law should have limits to consent over significant bodily harm. And it's clear that the debate remains unsolved today. So I know that our discussion throughout probably answers this, but I just want you to kind of sum it all up for me. But just out of interest, where do you sit in regards to consensual bodily harm, such as sadomasochism?
Yeah, I think if you're two consenting adults, or more than two consenting adults, if you're able to give consent, like in the true sense of it, as like given freely, you're not under duress, like you don't have any mental health disorders which would stop you from being able to consent properly. If you can do it properly, then what you do is up to you in your own home. Otherwise, it does end up as this weird, oh, it's not okay for men to be doing it, but it's okay for husband and wife. But then if we protect in public health, like I said earlier, then there's so many more people who should be criminalised. I think, yeah, it should be a case of consenting adults, then that's up to you. Draw the line at if you cause the death.
Yeah.
That's to me a different matter. It's not for me, personally, but what you do is up to you and should be up to you and should be kept out of court.
Yeah.
That's another thing. If your argument is a cost to the NHS, why is the fucking taxpayer paying to criminalise these people and pay for them to be in prison for no reason? But we're letting rapists walk the street.
So R.V. Brown really did transform the law of consent and bodily harm. Before Brown, the limits were uncertain and scattered across a series of cases. And after Brown, although still unclear, it is more clear than before, even if it is highly controversial. More than 3 decades later, the case remains a focal point for discussions about autonomy, privacy, sexuality, and the proper reach of the criminal law. And whether you view Brown as a necessary protection against violence or an unjustified intrusion into private life, its influence on English law is undeniable.
If you do have an opinion on this case, please do let us know and give us your reasons for not agreeing with us if you disagree with us. I'd be really interested in hearing that.
Definitely, yeah. Email us at anotherdayanotherevil@gmail.com or pop a comment on the podcast. I think you can also do that.
Yeah, or message us on Instagram or Facebook.
Yeah. So thank you for listening to the case of R.V. Brown and join us next week. Thank you for listening to Another Day, Another Evil.
This show was written and hosted by Melissa and Georgina Scorer.
All of our sources can be found in the show notes.
Stay safe. Goodbye.